either of the contractor to other side, we refer to the solar bid of an engineer of the authority mentioned.
Where is the procedure of demand?
My lord, the notice I have given, my lord.
No, any prescription in the clause itself giving notice in a certain manner?
No, my lord.
No.
There is only just a letter can notice to the engineering chief, my lord.
Okay, where is that notice?
That notice, my lord, lordship will finally come to page, my lord, 81, my lord.
Proof of service.
Proof of service, my lord. Lordship may kindly come to page 83, my lord. I've given that consignment.
Where is which serial number? Okay, okay, delivered. Okay.
Delivered.
Yes, we are issuing a notice.
Hello.
Hard. This is an application under section 11.
My lord.
Huh?
11.
Section 11 of the Arbitration and Conciliation Act 1996 for appointment of arbitration in terms of the contract, dated
Contract dated, my lord.
in terms of clause
My lord.
clause 70,
70, my lord.
clause 70 and 70 of one of the contract dated
Contract agreement.
29
Yes.
23/9/2016. Stop. Mr. You are Mr.
MR Adhikari.
M.R. Odhikari accepts notice on behalf of
All the response.
all the respondents. Stop. As duly serviced, no extra copies. What you say?
Notice may go.
Notice.
Yeah.
Okay, accept notice. Want to file affidavit?
Yes.
Okay. In the meantime, the respondents may file their affidavit.
I will also similar, my lord.
Huh?
Similar pertaining to another contract, my lord.
Give the contract number.
My lord, the
And-
contract number, lord, people find that page, my lord.
Give the contract date.
Date is, my lord,
Date is
Date is,
dated 15 to
15 to
2017.
17, my lord.
15 to 2017, same except clause and others will be same. Extra copies.
Extra copy. Oblige. May I please, lord?
Yes.
In this case, my lord, note may go, my lord, that you did violation of the one of the court order, my lord.
Notice may go. Okay, where is the order?
My lord, yes, at least 7.
This
The
is an
relevant
application assailing so and so, so and so. Order dated so and so, so and so. Peruse the pleadings. Full stop. A direction specifically was issued to the respondent number 2. Full stop. Though a direction was issued to all the respondents to cooperate. Full stop. At least accordingly, at this stage, let a notice be issued to the respondent number 2 only. Returnable on such and such steps within 5 days.
My lord, one also, my lord.
Why?
My lord, order also communicated to the one.
So what did he do?
My lord, he is the he releases the budget, my lord, and also
So he releases the budget, but before that, what is the direction?
direction is, my lord, to examine the claim, my lord, and thereafter he will sanction, my lord, and thereafter.
So first let there be determination by 2, then only contempt against 1 will arise.
My
4x. None appears for the petitioner on call. Please this matter after 3 weeks.
Okay. May the matter be taken
You are for?
and for filter development of it.
No petitioner is this what to do. None appears for the petitioner on call. list after 2 weeks.
I may say the lordship. My lordship petitioner, before lordship, he came for with a limited prayer. My lord, there was the agreement in between the petitioner and the respondent number 6,
Mhm.
and that agreement has been violated.
Mhm.
Therefore, a complaint has been complaint has been registered before the magistrate, executive magistrate. Executive magistrate has after receiving the police report, passed an order uh, mm, to maintain the peace and tranquility and not to carry forward the big industry. That order has been violated. That was not followed, my lord. And the deputy commissioner on our application that action may be taken. The deputy commissioner is also not taking it. So my at this stage, my lord, limited prayer, my lord. My lord, admittedly, it's a civil dispute. So,
Admittedly, a dismissal with a reason which may affect everything, even your, because Mr. Sikdar, it's a contract between you and respondent number 6 or 7. Now, on the basis of your lease agreement, violating your lease agreement, respondent number 7 has allowed the brick clean to operated by some other respondent.
Right.
And you have gone through the executing court. And executing court has the 145 court. 145 court has passed an order which is beyond its jurisdiction. We will not comment on that. We will not comment on that. That order has been passed. Other side is not agreed. If you want that this matter should be dismissed,
my lord, maybe
see,
at liberty.
dismiss, then we'll give a detailed order which may affect you.
My lord, we
And
may
if
say-
you say we want to withdraw, we'll allow you to withdraw and to
Well-
opt for your
yes, my lord.
art
Well,
matter.
With liberty to approach the
Appropriate forum. We are saying not anything. Mr. Sikdar, learned counsel for the petitioner, submits that he may be allowed to withdraw the present petition and seek appropriate remedy before appropriate forum.
Right.
And not before this court. Prayer is
Deeply.
allowed. Accordingly, this petition is dismissed on withdrawal with a liberty as read.
Lord, instead of dismiss, my lord, instead of my lord,
This petition is wasting
Well,
time.
others-
This is wasting time of this
my lord,
court.
other side approach this court. That therefore, my lord, yeah.
We do not know. This is not a jurisdiction. of- Yes.
Deeply.
May I please tell Lordship?
Mm,
Lordship, what happened is actually,
mm,
I purchased 2 numbers of flats actually, from 6 numbers of flats.
Mm.
I had purchased one in the year 2016 and
Mm.
another is on 2023.
mm.
Now what happened when I purchased,
Surface.
Lordship,
Tell us,
Lordship,
tell us.
yeah. What happened is actually when I purchased in 2016,
Mm,
so I got a loan from the Procomat dependent number 5,
mm,
which is the PNB Bank. And in 2023 also I had
Surface
purchased the
check.
ground floor.
Securitization and reconstruction. Yes.
Lordship, before I proceed actually, I would like to state one thing actually.
Yes.
There is a case law known as the South Indian Bank actually, which was done in 2023,
Mm,
which says the majority of the DRT related cases, majority of the surface, this one has to be go to the DRT. But in this case, I do not fall under the framework of this South Indian Bank cases.
why?
Because the thing is that the apex court also has been said actually,
Mm.
there are instances where this may not be, this may be entertained by the High Court. There are main three actually. Say, plea by the guarantor of teachers under section 133 and 135 of the Contract Act. Second is that a plea of fraud. A plea of fraud, because the DRT actually, there is no such thing as when there is a totally of fraud is there. And in the case of actually a leading case, in the Whirlpool Corporation versus Register of Trademark, Mumbai,
Mm.
there were 4 instances which the apex court has said ki this type of cases can be entertained by the High Court. Number 1 is there where the writ petition is enforcement of any fundamental right.
Mm.
Number 2 is that where there is a violation of principle of natural justice. Point number 3 is that where the order or the proceedings are wholly without jurisdiction. 4, where the virus of the act is challenged.
Mm.
And then also number 1 in the recent judgment, Messrs. Godrej, Sarah Lee versus the excise and this one, officer come, the Supreme Court gave out the 5th exception also.
Mm. What is that?
That where the controversy is purely a legal one, and it does not involve disputed question of fact, but only questions of law, then it should be decided by the High Court instead of dismissing the writ petition on the ground of an alternate remedy being available. Apart from that, actually, I could like just there is one this thing, because I could like to convince my lordship that this case can be entertained here actually. In the Supreme Court,
That objection is not yet been raised.
lordship,
That objection is not yet been.
I am in his favor only. I am
He-
former. Only one thing, if I may point out, my lord, in today's daily cause list, my lord, one connected matter is fixed before court number 1.
What is that?
That is, my lord, item number 17 WPC 1522 of 24.
That by the
I will
secured creditor.
No,
No,
not
no,
the
no,
secret credit matter.
there were 6 numbers of flats, as I said actually.
No. See, let us not go to so much of detail.
Yes,
Your
ma'am.
case is this. You purchase the flat by taking loan from somebody. And said building or building was also mortgaged to another bank. Therefore, that bank secured creditor has taken action under SARFAESI Act.
Yeah.
Ultimately, it went to the stage of section 14 when a magistrate is empowered to take
Physical
take
credit.
over the physical possession.
Good.
At that stage, you say that, see, I am a bona fide purchaser with a loan from a bank, and therefore you cannot take over this property without taking recourse to the SARFAESI. That is your case.
One factual metric has been.
Yes, Ganguly will issue a notice and not to do at this stage, or what you say.
Lordship,
Well,
what
I
is
am performing this matter. In fact, I am the, my lord, prior mortgage in this case.
Okay.
So he is not
2016?
seeking relief against me. He's
Ah.
seeking relief against
Okay.
2 and 3. But this respondent number 3 and 4,
Mm.
they have filed a caveat, and that other matter is listed in court number 1.
Where is that caveator here?
No, here he is
What
responding.
is the other matter?
It is
Filed by you.
Filed by me only.
What
the
is
same
that
case.
issue?
The issue is, this is the flat number 302 and 102. That one is for the flat number 302. And
Why
flat
it
is
Two
flat.
flats in same building, but
Two flats.
persons are different.
Persons are different.
The mortgages are different.
No, why then this is here, that is there?
That only the registry.
But
will-
This is also a matter to be
Yeah.
dealt by as a division bench.
Perhaps, my lord, when this
Ah.
SARFAESI aspect, perhaps they have listed it.
That is why this.
Here, I could like to say that one point. what
No,
you
this
can-
matter is to be listed before division
No.
bench, I think.
No, but here the matter can be listed because it relates to a land matter also. This is relating to land also. Because the thing is,
Land is a part of SARFAESI, or land cannot be taken by SARFAESI.
no,
This is
can be, it can be.
an action under SARFAESI.
Lordship, what I want to say is that after selling of the flat, as we have, Lordship has been said actually, in 2016 and all, 2020, the builders had given the land papers to the Bank of Baroda.
And we understand. According to you, moment you have purchased the property, mortgage it with the bank on your sale deed, that original title paper could not have been transferred to a third bank.
Okay.
This is your case. That we understand, but when it is an action under SARFAESI, it is to be listed before division bench.
That is, but
What
I want to
but?
what I want to convince my lordship is that because
This matters pertains to a challenge to a action taken under Surface Act. Accordingly, list this matter before the division bench. As the petitioner has expressed urgency, registry to do the needful for listing the same at the earliest.
Made Lord. Your Lordship, may I remember my that Tilapatar
We'll issue a notice.
notice and fixing my on the same date
We'll issue a notice here.
and my records were called.
That will heard Mr. R.P. Sharma, learned senior counsel, assisted by A. Deka. Aggrieved by a proceeding and a resolution dated 5/1/2024 relating to the no confidence motion against the respondent number 7, the present petition is filed. It is the case of the petitioner that though no confidence motion was again issued by the petitioners, however, a fabricated resolution was made showing that no confidence motion has failed. First of issue notice returnable on evaded.
Other cases,
When?
22. One
20.
WBC 168 of 2022.
22 this month.
Yes.
Then it will be a very short.
No.
Okay, okay.
Let it come on that day, my lord.
It is submitted that another matter. So therefore, we are not issuing notice at this stage. We'll fix that on 22nd.
Lord, order may go mal production of the record.
No, there in that there is already production of record. So it will let it list on that day.
Yes.
Submitted that another writ petition pertaining to the same challenge, same no confidence motion is pending, being WPC number
168 of 2024.
168 of 2024.
Yes.
And same is fixed on 22nd of March 2023.
Yes.
List this matter in the motion column
Along with
along with
that.
the said writ petition on 22nd.
My lord, for the timing, my lord, after some time,
Why?
can you please another put with me? Put number 8, my.
What is the case?
I'll-
Heard. You are Mr.
Wiley,
Why?
Ali.
Ali, learned counsel for the petitioner. The grievance of the petitioner is that during the last settlement operation, the patta land of the petitioner has wrongly been recorded as government land. Full stop. On grievance raised before the deputy commissioner, which district?
Dhubri,
Dhubri. An inquiry was conducted and the circle officer by its communication dated 22/2023 addressed to the additional deputy commissioner within bracket revenue Dhubri admitted that there was a mistake in during the settlement operation and the petitioner's land, patta land, has been recorded as a government land. If that be so, the government land. However, it is the grievance of the petitioner that even after such report of the circle officer, the deputy commissioner is not taking any action. Stop. In the aforesaid backdrop and limited grievance, the learned state council shall obtain instruction from the deputy commissioner to Dhubri whether the Annexure 1 document is a correct report that has been filed by the circle officer. And if so, what action has been taken by the deputy commissioner thereafter. Please this matter in the motion column on Just a simple, he has said, we can dispose it of, saying that deputy commissioner, but we do not know whether it's genuine, not genuine, whether this was a report. So you have that, huh? Okay, give this on next Monday, list on.
Hello.
No, not first of April. What is the date next Monday? 26th is also holiday. 27th.
Hello. May I please repeat?
When the accident took place?
3/10/2020.
Accident, write down. 310,
Yes, fine.
310,
3/10/2020.
310/2021. And who are you?
I'm the wife of the deceased.
Wife of the deceased. What is the period required? We do not want a contempt.
Lord.
8 weeks, 10 weeks to dispose it of.
So maybe in earlier order. Lord,
No, we'll dispose
was
it
allowed
of, but how much time do you require?
to keep it up.
3 months, 4 months
Lord.
from the receipt. Yeah, get out of dispose.
Take
Dispose of.
care.
Yes, Mr. Das.
The petitioner office had applied for partition of his land lot
Hmm.
under the CRCP portal to planned by the government of Assam
Hmm.
under Mission Basundhara 2.0 under the Assam Right to Public Service Act itself. So if no reply has been given, lot, I filed a first appeal.
Give the act, give the act. Yes, madam.
Act,
You
local,
know,
I
this
have,
is a policy of the government, very welcome policy that people need not run from pillar to post. There is a specific period. They will apply, that will be rejected during or accepted during period. Specific period for appeal, then second appeal. Everybody is sleeping. What is this? This is a failure of the policy. You reject it. You reject it. No problem on that. Day after tomorrow. This is a bad reflection of the administration upon the government. Sitting over, absolutely sitting over. And we may impose cost also if we found that there is no reason to be there. The grievance of the petitioner is that the petitioner had applied for partition of 3 Katha 10 lesas of land in the Seva Setu portal. Full stop. The state of Assam, the state legislature has enacted a legislation, namely Assam Right to Public Service Act 2012, and certain guidelines has also been issued in exercise of power of the aforesaid act. The object of the said act, where is the act? It can print out my tweet. Yes, Mr. Das, do you have the copy?
Okay,
Anybody is having the copy? Very good.
another
The object of the act is to provide for delivery of notified public services to the people of state of Assam within a stipulated time and for the matters connected therewith and incidental thereto. To give to facilitate the citizens with certain public services, specific time frame has been issued under the act. However, However, the grievance that has been raised in the present petition is that non-consideration of the case of the petitioner even after lapse of time. The allegation is that the petitioner filed such application on 26/11/2022, and in terms of the said act, such application should have been decided within a period of
3 months.
3 months. However, when such decision was not taken, the petitioner opted to prefer an first appeal provided in the act itself on provided itself
30/10/2020,
30/10/2023,
2020.
which in terms of the mandate of the act ought to have been decided within a period of
60 days.
60 days. However, even after elapse of 60 days, nothing has been done, and having no alternative, the petitioner had preferred the second appeal provided under the act. However, such second appeal has also not been decided till date. Full stop. If that be so and correct, this is a very sorry state of affair in very sorry state of affair in the state of Assam. And if this is the conduct of the conduct, then it is a total defeat of the object for which the state legislature has enacted the act. Be that as it may, at this stage, MS.S. Sharma, learned counsel representing the state respondent, submits that she may be granted time, 2 days time to obtain instruction as regards the status of the application of the petitioner and the reasons of keeping the aforesaid application pending beyond the stipulated time period prescribed under the act. List this matter day after tomorrow. Keep a book. Leave it.
All right.
Timing.
Why?
That's it.
This is regarding his.
Who are you?
While he is the local resident.
So what
of
is
that
your
locality.
difficulty?
Difficulty, your lordship may kindly see the construction, how it is going on. And I have annexed the photographs also.
No, we have seen that. You are the next door neighbor.
Yes.
Your house is next.
Yes, ma'am.
Where is your statement?
Local, I am the resident.
No,
of
forget about
that-
local resident.
Not next door, but near the inside in the locality.
You'll have to first
Minor-
satisfy your intention of this petition.
This is.
Where is the Silchar Municipal Board? Somebody appeared in another case.
My lord, S. Doctor.
Just wait for some time. Another matter we have adjourned. We'll just wait for some time as doctor. Yes.
Before I begin, Lordship, at page 4, Lordship, I have inadvertently added the name of the one of the officers, Lordship. May I permit-
Where is excise? Yes,
Lordship, I'll have to take instruction.
hard. Mr. BP Bora, learned counsel for the petitioner. The present petition is filed challenging an inquiry report by the executive magistrate and a consequent show cause notice by the deputy commissioner dated 27/2/2024 on the ground that said exercise has been carried out by the authorities not having authorities not having competence and jurisdiction under the Excise Act and the rules to rule and the rules framed thereunder. Where is the earlier litigation?
Yes. Earlier litigation not to be defined at page 40.
It's 40.
Page 31. Our litigation is page 30, 33.
Where is the operative portion?
Operative portion, Lordship, page 30,
The petitioner earlier approached this court
37.
you are one of these Diganta Sakya?
No, Lordship, I am the license holder,
Okay.
Santanu.com. I filed it. I was disposed of the entire petition.
What was the direction in WPC, first WPC?
Yes, Lordship, page 37, Lordship would find at page 16.
It's 37.
Page
Paragraph
30,
16.
36 and 37. Last para. Page 38 is last. I dispose of this writ petition as well as the IA by vacating the interim order, thereby granting leave up to the respondent authorities to process the MFL on
You are
license.
the respondent number 7
Yes, yes,
in this writ petition,
yes, yes,
isn't it?
yes.
Earlier, a writ petition was preferred challenging the issuance of license in issuance of IMFL on license in favor of the petitioner by some aggrieved parties, which was disposed of. Initially, there was an interim order. Subsequently, said writ petition was disposed of with a liberty to the respondents to process the IMFL within inverted comma on license in accordance with law, with a further direction that the provision of Rule 294 of Assam Excise Rules 2016 is adhered to in letter and spirit. Subsequently, that is the writ petition. There is
That
no
is the
writ-
writ petition. Thereafter,
Hmm.
again, the deputy commissioner kept it pending. We filed an IA. Lordship would find the direction at page 48.
Okay. When the license was not issued, the petitioner preferred a writ petition.
Preferred an IA,
Where?
page 48.
No, IA in the earlier.
IA in a writ petition, Lordship would find the writ petition in page 51. In that writ petition, another round of writ petition was filed. Thereafter, because of that,
Then when license was issued?
only on 2023, 24
Where is that?
license, Lordship would find that at page
Subsequently, the license
28.
was license in favor of the petitioner was respondent number 7 in earlier writ proceeding was issued on
24/11/2023,
24/11/2023,
page 27.
and thereafter the inquiry was initiated. Inquiry was initiated as per in terms of section 294.
Yes, 290.
294 of the Excise Act. Full stop.
Lordship, now an
29
emergency search has taken place. That is absolutely in violation of the rule.
Full stop. It is the case of the petitioner that the exercise of power under section 294 can be done prior to issuance of the license. Isn't it?
Yes.
Prior to issuance of the license, and when the license was issued, the inquiry, it is presumed that inquiry was duly done. It is further case of the petitioner that recently a search and seizure was conducted
On 28/1/2024.
on 28/1/2020, not recently, on 28/1/2024, which also without jurisdiction
Without
and not
jurisdiction.
permissible under law. considering the matter in entirety, let a notice be issued, returnable after 6 weeks. And Mr. Borthakur accepts notice on behalf of all the respondents.
Excise department.
Huh? Excise, tell us who are the respondents. Bora,
I'm 4 and 5.
Mr. Hendik 4 and 5, Borthakur,
Others.
others, Borthakur.
I cannot take up 2 dots. So by name, they have been made a party.
One and
2.
not 2. You are for 1,
No,
You are-
I'm for 4 and 5.
4 and 5. Who is for 1?
For 1, I'm there.
Except 2, all are you?
Yes.
And Mr. Hendik is
4 and 5.
4 and 5. Except 2, will go to the notice, huh? Notice to respondent number 2. Notice to respondent. Considering the matter in entirety, it is provided that no coercive action shall be taken against the petitioner pursuant to the inquiry conducted. Till the next return.
May people. Particular notification under tenant is at page 19, annexure 1.
Page 19.
Annexure 1.
Hmm.
This is the notification by which the Bhairvari with Senibari,
Hmm.
Borkhat and Bagherka.
What is your
Tiger-
remedy under the provision?
Lordship. Only the deed would be there.
Why? Suppose you have a grievance regarding this notification.
Yes,
Now, whether it is 50%, whether Boro community or non-Boro community, who will decide?
Lordship, for that. they have
No,
filed-
we'll just answer that. We'll go to other things later.
The deputy commissioner will have.
Who will decide? There is a grievance redressal mechanism under the scheme itself.
Lordship, we have.
Governor,
Lordship, we have made.
there are some
representation.
judgments earlier. Madam, you are not aware. When initially after BTC creation, thereafter something was there, then hundreds of writ petitions were disposed of. See, same issues were. Are you not aware?
Lordship. In this
Are-
case, we made representation
Reservation before whom?
before the secretary, chief secretary, additional chief secretary,
Department.
home department.
Hmm.
And those representations are pending. They have not disposed it. And these villages, the sixth schedule, the provision procedure adopted, mentioned in the sixth schedule has been filed. So that is why we are before your lord.
Or Mr.
GP and Portland Department.
Amoli Learned Counsel for the petitioner. The present writ petition is filed challenging a notification number EFC 263140/2 dated 13/12/2022 issued by the Principal Secretary to the Government of Assam, GAD Dispur, whereby the petitioner's villages were included within the administrative control of Udalguri district from the Dorong district, inasmuch as brought under the BTC area. The basic grievance of the petitioner is that the procedure prescribed under 6th schedule of the Constitution for inclusion of such village, inasmuch as the procedure prescribed in what was that act?
One, no, lord, these
Ma-
are accords, MOS, Memorandum of Settlement,
And
of accord.
in terms of memorandum of settlement,
2003 and 2000 BTR Accord 2020.
that within bracket BTR Accord 2020
That is different. 2020.
2020.
Two
Issue
accord.
notice returnable after 4 weeks. MS,
I'm only for respondent is GAT department, and
will GAD?
GAT's name not shown in the cause list and Portland Welfare Department also not shown in the cause.
Bodoland?
GAT.
Borderland?
Portland Welfare Department is.
Welfare.
Who is standing council? Okay, go for GAD.
Respondent.
Respondent number
2.
2. Bora for
I am for respondent number 3.
respondent number 3. 5 and 6. And who remains? One. Who is one? Oh, Jogan Hendik, 1. And any other respondents?
Respondent number 4, WPTDC department. Water and Welfare Department.
Who is
Ardhar.
Ardhar?
There
As respondents are duly represented, extra copies be furnished. Anybody? Okay. A registry to notice vehicle, returnable, so and so, except so, no formal notice. Extra copies, 5 days. Last thought, registry to list this matter showing the name of the respective council in the cost list.
My lord, in this case, my lord, I have challenged my lord,
Hmm.
the notification of an election candidates declared in violation of my lord rule nine.
There are provision in the Pharmacy Act itself,
For preparing appeal.
huh?
So there is the election rules also.
Election rules under,
Election is there, but this is appeal provision is not there. On that.
so no, see, if there is, your basic grievance is that there is a defect in counting and all.
Not only that,
Not only, many defects.
but the serious defect is this, my lord. He have to keep the all ballot allowed with the form B and form C for 6 months in a separate taking. That was not done after election. That was counted on 24th. He destroyed all the papers. on
Okay,
26th.
now we cannot revive that. What kind of remedy we can, what direction can we pass in this?
So it is the only alternative is to hold the face election. Because my lord, they have to obtain the instruction. If the everything is destroyed, I paid for the recounting. And the
Art,
recounting
Mr.
was also not done.
Bor-
And I have lost the police affair. Violating the all rule, my lord, the election rule, my lord, the 1959. Access ballot, everything was there, and notification also not under his authority. Notification as per 91A.
As Mr. P. Mohan, honored counsel for the petitioner. The present petition is filed assailing the conduct of election by the Assam Pharmacy Council being violative of the act and the rules from there being conducted in violation of the Pharmacy Act and the rules from thereon. Full stop. Mr. Gogoi accepts notice on behalf of
1, 2, 3, all
Except the private respondent.
except
Except
respondent number 1 to 5. Notice to respondent number 6 by registered post with heading. So, Mr. Gogoi has raised the maintainability of this petition, saying that the matters pertains to election and there are separate rules for conduct of election under the Pharmacy Council Act. Pharmacy
1959.
Council Act. Full stop. Read it as it may. Issue notice.
5 and 6 may be by registered post because 6, the respondent 5 has been impleted by name as respondent number 6. So 5 and 6 by registered.
5 and 6 were registered.
So 10 will be common.
Okay. Such question of maintainability.
My lord, I paid for the stay because
is
the
capable-
because
Stay of
my
what?
lord, my lord, one thing, man. I told you in my notification how they have violated, my lord. This cannot be.
My lord,
They have
this
to
regard-
keep-
Just a minute. What you want to say?
My lord, the notification that was published on 24th, that
Notification of what?
it is elected candidate of 6. That
No
will not be
election can be stayed like this.
No, no,
Mr. Mohanta, you are aware of the law.
I know, but whenever the culpability, my lord, gross violation of the provision, that can be violated in by the law.
Okay, show us some authority.
But whenever provision is there, they have to keep it 6 months for the entire paper. The 2 days before,
That is
after
the
one, they have
recounting.
destroyed. Now, where is the recounting that possibility is there, my lord? If anything is there violated, nothing can be palpably came out. My grievance is this, my lord. He gone extend everything. He favors the law. That cannot be violated being the returning officer.
Show us what is the provision.
So, my lord, please,
See,
This
two
is the provision.
things, we will consider your interim
Yes.
or we can issue a notice on interim.
Yes.
If we consider the interim today, we'll decide the interim. Option is yours.
my lord.
If you,
Notice my interim, by this time,
No.
let them take the instruction to.
because
we all
we,
think-
prima facie are not satisfied to grant an interim, let us be free. If you can change our mind by arguing, no problem on that.
No, my lord, only by I want
But
to.
then if we proceed on hearing, we'll decide the
My
interim.
lord, I want to.
Either rejecting or accepting.
Before that, my lord, I want to lordship at place before this rule on here. This just go to the rule.
So we are proceeding in the hearing regarding interim.
Yes, well, I am ready, my lord. But the
Okay.
thing is that, my lord, this so many rule is there, my lord, lordship have to cancel of the. My lord, notice may issue, my lord. But if I
No.
want to show the notice.
No, notice we have issued. We have, we can issue notice on interim or
Yes,
decide
my
by.
lord, notice of interim.
Okay. Notice on interim. Huh? On the same date. Give a date returnable on. Since interim's question is there.
And another matter, my learned friend, is pending.
Huh?
Okay, plus-
Gogoi, 25th of April,
Yes, sir.
25th.
No, no, ये तो आपका
100.
अपना जैसे ground पे है।
May be the point.
Yes,
Well, this is for compensation for acquisition of land and Assam Mala scheme.
Hmm.
Let the scheme provided for the notification provided for direct purchase negotiate under for negotiated settlement. No negotiated settlement took place, my lord, in fall, and the award has been passed unilaterally. Against that, my lord,
No negative, let me take it first regard to settlement.
okay. Where is the Assam Mala scheme? Have you annexed it?
That is already been annexed.
Annexed, page?
Please rotate.
Mr.
Active or
Yes.
set up.
The grievance of the petitioner is that the petitioner's land has been acquired in terms of a scheme called Assam Mala. And in purported and under the provision of negotiated provisions of, where is that provision?
provision is, my lord,
Provisions of negotiated settlement,
my lord, it paid.
Serial number 4.
serial number 4. Has been acquired in terms of
The notification also provided negotiated settlement.
in terms of such negotiated scheme of negotiated scheme through direct purchase by way of negotiated settlement. Notice is to be given to the landowners regarding the proposed purchase. Where is the last provision sale?
You have to see, my lord, connected to page 19. This is the notification. It says that under negotiated settlement. I should. Then, my lord,
And
that-
thereafter, the payment is to be made after the procedure, after adhering to the procedure prescribed under clause 3 of the
Statement.
said scheme. It is the case of the petitioner that without there being any negotiation as prescribed under Rule 3, the petition, an award has been passed under the aforesaid scheme behind the back of the petitioner. Full stop. issue notice, returnable on, give a date.
Not an award. They then notice to make them object.
No,
Yes.
no, award pass, the other 26 annexed to
Page 19 is the notice.
page 29.
No, notice is given. They say that without hours negotiation, that is their case. Page 29. Where is the award?
Page 29, man.
An award.
Right.
At award as annexed as annexer
3.
3 has been passed. What is this? You must have a training for all these people. Atrocious, we'll call it atrocious. What is the construction?
Construction of development of road. Right?
Road is constructed. Full stop. The notice na laga. The award itself shows that the award reads as follows, page 29. Now, have you appeared before them?
No, till now I have no instruction. My lord, they are not.
This is the award of 2021. Is it not your responsibility to say and go that no, you cannot pass this award? Because notice itself says if you are interested to receive the said amount,
My lord, my representation is there, my lord.
everybody is half-hearted. So they will, as he is arguing, they will argue that this is only a notice that we have determined this. Please come and say whether it's agreeable.
Award is, it says, my lord, award has been passed.
If award has been passed, that may be award, but with a condition that if you are interested to receive, come. So meaning thereby, if you are not interested, this word award is passed, used, that is not a award in fact. He's correct.
An award has been passed for rupees such and such under section 23 and 30 of that.
We do not know what happened thereafter. Equal. Issue notice returnable after 4 weeks. Give a date. The state, more particularly the deputy, the collector of the concerned district may file an affidavit or apprise this court whether the procedure under the scheme formulated by the government of Assam government of Assam on 7th of March 2022. Where is your power to do this? We have serious doubt. Nobody has challenged this. God save you. Please show us, we'll just, Mr. Hendik, enlighten us the power under 2000, the mandate of the Fair Compensation Act 2013, the procedure required for land acquisition, the procedure, and I think section 26 is there. Section, what is the mandate of 26? Where is your competence to issue a notification like this? We'll take judicial notice.
Lordship may kindly produce para 2, my lord. I have explained my lord. Para 2 of my petition at page 6, my lord, where I have explained my status, my lord, at the petition.
Go to the,
Yes.
go to the division bench.
Yes, my lord, this petition may be converted to PIL.
We will not convert it. The petitioner who claims to be a law-abiding, conscious citizen of India and being a law-abiding citizen and a social worker, according to him, he has preferred the instant petition, keeping in mind the benefit and well-being of the student of Government Girls Higher Secondary School, Silchar. It is the grievance of the petitioner that the Silchar Gov Girls Higher Secondary School has been constructed in violation of the extant norms and bylaws for construction of such a building. It is the further case of the petition that the petitioner has represented the public of the aforesaid locality and he is ready to pay any cost if imposed by the honorable, by this court. Full stop. The grievance raised and the pleading made is essentially shows that it is the case of the petitioner that he is espousing a cause of public interest and he has represented the public of the aforesaid locality. That being the position, this court is of the considered opinion that the petitioner cannot be said to be an aggrieved party to entertain a writ petition. More particularly when it is not registered as a public litigation, a public interest litigation. As this states, S.B. Chaudhuri, Learned Counsel, submits that she may be allowed to withdraw this petition and file a public interest litigation, with a liberty to file a public interest litigation. First, the player stands allowed. Accordingly, this writ petition since is closed with a liberty as placed for. Mr. S. Datta, Learned Senior Counsel, assisted by Mr. Siddhant Datta, for the respondent municipal corporation is present.
Municipal board.
Huh?
Municipal board. Is yet to
Municipal
be
board,
confirmed.
municipal board.
And for what?
One and
Obliged.
your may not be necessary, but Mr. Doctor's recording of name is necessary on the motion day.
Yes.
That's why we have recorded.
Obliged.
It's the case also for it. Mention is a share price of holder having more than 150 restaurant card.
Mm.
They are transferring the restaurant card to the other
Yes,
locality.
go. Chaudhuri,
Lordship, here the affidavit is ready, but the difficulty is that respondent number 8, Lordship, Assistant Director, no one is manning that post for the last 3 years. And the next high level post is Deputy Director. For signing it, Lordship, that the difficulty has
but
arisen.
your department is being run.
No, that's a Deputy Director on in charge.
So let
Lordship.
the deputy director
But-
file on behalf of respondent number 8.
But he is lower in rank and that's why, and he has not been made a party here. Deputy, that's the difficulty, Lordship. Otherwise,
On behalf of the head of the department, let somebody file this affidavit. That cannot be a issue.
that's the difficulty. The next is the senior assistant, Lordship. That's
No, there is some. Let us see who are the respondents.
issue involved connecting with this Udalguri division, Lordship.
Secretary, Food and Civil Supplies. Consumer Affairs, Kokrajhar. Director, Food and Civil Supplies. So you are representing respondent number 5.
The respondent number, I'm appearing on behalf of the BTC, but the respondent number 8 office is the main party dealing with the issue in hand, Lordship.
So assistant director is no more there.
Lordship, post is there, but no one is holding.
Now
the
who
post.
will have to file, who is looking after the office?
And the next higher level post, deputy director, Lordship.
So tell that simply that since
Then
no
Lordship-
assistant knows no respondent number 8 is, post is vacant, as since I am, that will
Lordship,
not say what
that-
should be.
That's how it's has been written, Lordship, within today,
Okay.
we'll. file it.
Mr. Chaudhuri, learned counsel for the respondent number 8, comma, whose affidavit is necessary, submits that he will file the affidavit within a period of 3 days from today. In that view of the matter stands adjourned and be listed.
Lordship, any day.
He might have to file but you file it.
Lordship,
There is an allegation of contempt also.
Lordship, everything is ready, only that. correction
That's
has-
why. When Mr.
Lordship, 2022 matter, and it has been kept pending.
We understand,
There is a-
but if we can file by, say, this
By
week
tomorrow,
also,
by tomorrow,
I
Lordship.
have no
I'll
objection
file
to
it.
that. I have no objection.
then when you give a date,
Any date, Lordship, convenient.
3rd of April.
Only thing is, Lordship, in the content proceeding, there is a direction for personal. They have not appeared till date.
Where is that personal appeal? I contempt.
Lordship,
Who represent?
Lordship, the date that was fixed, Lordship, the bench could not be, could not. did
Okay.
not sit,
On
Lordship.
23/6/2023, it has been ordered,
Thereafter, Lordship,
Lordship, who
today it has been
ordered-
dated.
has been 23/6/2023, and fixed personal affairs on 27/7/2023. (23/6/2023). In contempt case 61 of it.
Contempt. A direction was issued for personal presence of the of respondent number, personal appearance of one Sri Nogan Boro, Assistant Director of Food and Civil Supplies and Consumer Affairs, Udalguri, BTR, on 27/7/2023 at 10:30 AM. The matter was thereafter not listed on 27/7/2023 and listed on 25/9/2023 and thereafter on 5/1/2024 and today. You are supposed to take respondent number 4 first steps. You have taken. The steps directed to be taken on that day it was not listed, so we cannot find a blame upon them.
I can take a fresh step also.
No, respondent number 4.
Lordship, they came, Lordship, but has to return back.
No, respondent number 4 also appears. This service is complete in this
Yes,
regard.
Lord.
Mr. B. Chaudhuri, learned counsel, this is in the contempt, submits that he will be able to file an affidavit.
On the next, same date, Lordship.
Okay,
3rd of April.
by week. Accordingly, list this matter on 23rd of April, 23rd? 3rd of April, 3rd of April, along with WPC 4017/2020.
Highly applied. Interim order to possible.
Interim order pass earlier, interim to repetition. Interim order pass earlier.
WPC.
WPC.
May I please, Lordship? In this case, the earlier they have refused to accept the notice. Now the notice has been delivered. So my lord, the
Will
matter,
anybody appear for respondent number 5?
nobody,
This matter is ready as regards service. However, none appears for the respondent number 4.
Lordship, matter,
Five. Is this matter in the admission column on?
for first week of April,
Give a date first of April.
a small issue is involved, demarcation. 4th of April,
4th of April.
of life.
This one. Very good is survived. Yes, what
Hello, in
Yes.
this case, my lord, I am appearing for respondent 5, my lord.
respondent number?
Five.
5.
Hello, we need some time to file affidavit. First time appearing.
Learned counsel for the petitioner press for and is granted
No.
2 weeks time.
No, but I'm for respondent.
Respondent number 5. 6 for 2 weeks time to file affidavit on opposition. Prayer is allowed. The interim order passed earlier shall continue until further orders.
Hello, obliged. May I please? Lord,
Yes.
if here I was to file the affidavit of service that I could not file, I will file it tomorrow. The petition.
Who are you?
HK Sharma for the petition.
No, who are you for the petitioner?
Petitioner. Two petition.
And what about the service?
Service, my lord, justice service has been taken upon respondent 6 and 7.
Have you taken?
Yes, my lord, that is been taken. I will
Affidavit
file.
file?
No, man, that I will file.
Okay. Learned counsel for the petitioner submits that service to Dusty has been taken upon respondent number
6 and 7.
6 and 7, and he will require 5 days time to file the affidavit in this regard. Accordingly, he prays for an adjournment. Prayer sense allowed. Please this matter. Please this matter. Second, last part of April, after Bihu. By that time, your exams will be over.
Yes, most probably.
Okay, that's why I'll give it.
Basically, my lord, it will become instructor.
That's why. Give the list this matter last part, first week of May. 2nd of May, 2020. Interim order pass earlier shall continue till then.
Much obliged. Yes, sir. It has been taken, my lord.
Notice to the respondent respondent number 2 and 7 were issued only on 1/3/2024. Await service report. List after 4 weeks. Any interim? No.
Yes, madam.
Interim order passed earlier shall continue till the next date of listing. In the meantime, the other respondents may file their pleadings.
Yeah.
Yes, next case.
Public.
Yes, my lord. My lord, in this case, we had taken steps, my lord.
Hmm.
But as per the registry, the Laudima Court's note, it appears, my lord, that, my lord, it has been reported that they do not live there, my lord. Now, my lord, after getting that report, we had filed an IA, my lord, that is not on record.
For
My lord, we had filed an IA to bring on record, my lord, this letter, my lord.
in terms of office note dated 13/3/2024, await service report in respect of respondent number 5 within bracket A to
No, my lord, a report has already come, my lord. The
Uh.
envelope has come back. And in the envelope, if the lordship sees it, there is a record, my lord.
1/13/3 report was not there as per the registry.
No, my lord. The last occasion, my lord, so the envelope has come back with the report that, my lord, they are not found there. They are not living there. But, my lord, I have filed an IA to bring on record that the letter of the deceased.
No,
my lord.
in this regard to the notice issued by usual process, no service
Yes,
report
yes,
has been
yes,
received.
yes, that
And
is
as such, concerned section is directed to issue reminder for
no,
usual.
my
That
lord,
is what we are
that-
saying.
Yes, my- that is it.
If that is there,
That is my lord.
uh,
But then I have filed an IA, my lord, that may be also directly be placed on record.
okay,
my lord.
it is submit. Yes, you are appearing.
Yes.
5/1, 5/2, 5/3, 5/4. You are appearing for whom?
He's appearing for the Union of India.
Union of India. And madam, you are appearing for?
5 our client has got it. Let them.
Notice has gone. Now,
But
if
I have not
that
available.
their legal ears has not contacted you.
No.
Okay. Okay.
Well, if
In
you
the,
just take the
and
glance
it is
at this
submitted
letter.
that an IA has been filed for taking steps through
My lord.
paper publication.
No, my lord.
Then
Let us await service, my lord.
what is that IA?
But this IA is for the reason, my lord,
Kindly
No,
have
no,
a clar-
what is the reason
The
will?
IA is for accepting my lord the notice to be have been served because of the fact that the
No, no,
correct
that
address,
cannot be.
my
That
lord, it
cannot be.
was sent at the correct address, my lord. Now the report has come, the report is wrong, man.
No, Agojit order is related. Await service report. Mr. Nambila लिखी थी RK that चल
Oh, sorry.
No, no, no issue. None appears for the petitioner on call. Mr. H.K. Sharma, Learned Counsel submits that he will require 4 weeks time to file a.
No, Lord.
Okay.
Oh, instructions received, Lord. Yes, file affidavit.
4 weeks to file affidavit. In the interest of justice, though no counsel is representing the petitioner, interim order passed earlier is directed to be continued till the next date of this.
To be fair, my lord, there is another case pending of the same petitioner. It's petition number 5520.
It is submitted, it is submitted by Mr. S. Bora that another petition has been filed by by the petitioner, which was registered as
5520.
5520 2023 relating to the same issue. So accordingly, list this matter along with WPC branches. Notice.
Lord, I am appearing in this case for respondent number 4 and 5. Today I filed the wakalatnama. I need some time to file a reply.
The only thing, my lord, is the file. Section 14 application, my lord, it will have part of a road. Actually, a date may be fixed, but anything.
Will file when you can file?
At 2 weeks time.
2 weeks. Okay. After Bihu, last part of April. Mr. A. Das, Learned Counsel has entered appearance on behalf of Mr. Das, on behalf of respondent number
4 and 5.
4 and 5.
4 and 5.
And who others are appearing?
Others are government.
Mr. H.K. Sharma is representing the remaining respondents. Full stop. Mr. Das submits that he may be granted 3 weeks time to file affidavit in the petition. Prayer is allowed. Prayer is allowed. Full stop. In the meantime, the state respondent may also obtain instruction or file affidavit. The reason whether the respondent has not exercised its power under section 14 of the SARFAESI Act, and if so, the reason there.
But there was an order to file the C affidavit that may be.
It have
Since he's
appeared.
appeared-
Since the respondent has already entered appearance, affidavit and dusty service may not be required. Full stop. Please this matter on 29th of April
The admission for
in the admission.
Lordship, my name, Lordship, A is not there. Only 8.
That K has created many problems. That has created from HK Das. I always say him H Das and he always remind me HK. So now H has gone become HK. Will take after some time. Let the other matters be over. Mr. Chaudhary, some issues are to be deliberated in this. It's not as simple as we think. Is not it?
Either way, Lord.
Because we'll have to make a determination.
That's it.
It's not as simple.
It will take
Diverse views.
Lordship.
Even Supreme Court has not concluded. Okay, let it be. We are taking in this case. So that is not a binding precedent. And that context was different.
Yes. The rule was also different.
That context was different. So we'll again recall the facts of this case. When he entered and when regularization and for the purpose of benefit, what period was counted. Those will be-
Otherwise, my lord, he has been given all the benefit.
That Let the other matters be
No,
over.
let it be taken then on some other day, my lord.
Okay, okay,
But,
okay. Give a date.
okay.
Okay. Initially, I was thinking of releasing it because I am taking bench 4 and 5.
Right.
But yesterday I'm going through the issues.
Right.
I thought this needs some deliberation, an
No, you-
interesting issue
Definitely.
that has not been settled anywhere.
No, I've checked up.
I also said nowhere. Spent lots of time
Yeah.
yesterday on this, but so therefore I think we'll not release it from part.
Let it be in April.
But it should be within a period of a month.
Oh, then this one. Within a period of month, you know.
Can't we
Uh,
take it
April-
around last of this month, around
Yes.
before the holy vacation,
Or
so
before-
that we can apply some time, devote some time in
before the
Delhi-
Holi, then let it be after Holi. Yes. After Holi, because
No, I'm thinking of
Holi is-
before Holi.
or before Holi, then
The day before the holy vacation.
21st.
This color be with me.
21st.
21st. Be prepared on that.
Yes.
21st ki baat?
Lordship, in item number 21, we have filed our affidavit as well as additional.
Anything survives?
Lordship, still survives. Lordship, they have not released my goods fully. They had seized 7,290 bags of my supari. They have not released the entire bag.
Okay,
They have
now
released only 5
now
packets.
okay.
In fact, this matter may be admitted and fixed for hearing. Lordship, I'll just, Lordship, in brief, I'll Lordship inform what exactly had happened.
Before my learned
There
can
is a-
start, I am praying for a time today, Lordship.
Why?
That's because Lordship, in the cause list, we are misted, Lordship, at least taxes, so accordingly we have. I have not gone to the.
Taxation will be required.
In fact, customs of
Customs is also required.
Finance, tax will be required.
See, forget about other things. Moment you say that this is a Burmese origin, matter ends there. Police is having no power. There is a division bench judgment. It is settled. This is the custom. That's why custom is made a party.
And Lordship, there is something, Lordship, with this case. In Lordship, from the very beginning when the case was done, Lordship, earlier they said that we have done the search and seizure. While doing the search and seizure, they said this is because evasion of tax. Then Lordship, when we came up before the court that till now, you have not been given the power under GST to do search and seizure because GST had come into being, VAT is no longer there. So, Lordship, they started saying that no, you have done a stealing. So they levied so that I have stole the goods from somebody else. Thereafter, now they have come up with the thing that no, it is a Burmese origin. So they are changing their stand. Even before the division bench, the judge, because in this case, when the
They went to
interim order-
the division against the interim order.
interim order. Lordship, the division bench before the division bench, they have specifically submitted the Lordship PIO that we are not sure what offense they have committed. We are trying to make out. This is the Lordship observation made by the
We have seen that.
division bench judge. So
Now,
Lordship-
suppose we allow your repetition.
yes, sir.
Okay. According to you, they have, by virtue of the interim order, they have returned you back this amount. Actually, it should be this amount.
Yes.
Now, what is their stand on that?
Okay, what they have done is that the entire thing they have filed an FIR in their own police station. There is a PIO police station.
Anything on record in this affidavit as regard your allegation that I had 100 bags of Areca nuts. However, by virtue of the interim order, they have returned me only 90 bags.
Yes, sir.
What is their stand on that?
Lordship, they have not said anything. They have just filed an FIR in their own police station.
Mm.
And now they are only inquiring the things against their own because this is Lordship, this was seized by them. They should have returned me the entire thing. They have not returned. Now they are only inquiring their own case.
That
This is
how it was.
That's how it was.
Yes, Gogoi.
Yeah,
Who is BIO?
We are, Lordship, that is I am paying for.
But this is a matter of
Only for today, Lordship.
matter of 2017.
17 years, Lordship, I have seen, Lordship, but only for today. Any day as far
I
as Lordship.
think by virtue of the interim order and division bench and some subsequent judgments, so far tax is related, that is more or less settled.
Right.
If you say it's to be Burmese origin, then if you are also aware that yes, there are Areca nuts, So you'll have to inform the custom. There is detailed procedure under custom section rules how to seize, and of course you have a responsibility. You'll have to inform them. You don't have a power to seize and seizure if it is a Burmese. So you have taken different stances, different stages. Tax is not demanding any taxes on it.
But
Is
if
it?
the inquiry is already over, we have given bank guarantee also to them.
Huh.
So after inquiry, they found nothing.
Then
In fact, we were also praying that the bank guarantee may be released now to me.
when? After?
On 20
Just-
and 21st, Lordship.
See, this is only in a ventilation. We'll just remove it. You go through the interim order. All details it has been written. And thereafter it went to division bench. Then division bench determination is made. Day after tomorrow.
After tomorrow, Lordship, on 20 and 21st, Lordship, I am not available.
Give somebody,
Lordship,
and
Lordship,
somebody.
Lordship,
But on 21st, other matters also there, similar matters.
21st. 21st.
Lord-
21st. Then GST came, how that is to be decided. It's not that way. Since VAT it is increased, we will not pay. Whose responsibility? Different procedures are prescribed in the act itself. If the contract is silent, that act will be applicable. The learned counsel for the, but it's 2021. Respondent press for an adjournment. Prayer is allowed. Prayer not being objected is allowed. Please this matter after Bihu.
Hello, Bless.
May I please? In this case,
Where is FCI? Yes, tell us. The file. What is your state? What is your affidavit?
Lordship will see the respondent number 4 or 5 has filed the affidavit.
That we have seen. Their case is that yes, land acquired, this portion of land is under FCI. Now, what is it? That's why we have asked what is the stand of the FCI. We are not wasting time on reading this. We'll come
Your
back to
Lordship
that.
will see the annexed E method of the affidavit.
We want to see first the stand of the FCI.
That
What
is
is
what they have
I have
stated.
not gone.
That
Huh?
is what they have stated in the annexed of the response.
Yes, learned counsel for the FCI. Tell us what is your stand.
Lordship, in Annexure E, we have stated the land measuring etc. This is in reference to the letter enclosed herewith the Deputy Commissioner stating that in this regard, it is mentioned that
Take
based
your
on
seat. We can also read. We are asking what is your stand.
Well, Lordship, actually, in this case, I was instructed to take a date on this for admission hearing.
This is in order, or what?
This is for admission, Your Lord.
And then today we are hearing it. would you like to file a reply to this? No.
My lord. Yes, my lord.
Huh?
We'll file a reply.
You have filed a reply.
No, we have not yet, because the government have, some has, like, they take it time.
No, see, there are three issues. Their government has taken a stand in your favor.
Yes.
Let's see, we have acquired land, but this extra land is with the, it is say we have not, it are not under acquisition, we have taken. Their case is that whatever land is acquired has given to us, we have paid the money. So this is situation.
Yes.
In this situation, there are lines of judgment where court says that if it is wrongly been, Supreme Court says, taken possession, then the remedy is a civil suit.
That remedy is there, but here.
Remedy is civil suit.
Civil suit.
Now, they say that this is the what the land we require. They may say that we do not, according to them, they are possessing whatever land has been acquired. According to Deputy Commissioner, they are in over extra possession. Now, what Reed Court can decide until and unless you file a reply.
Yes, I'll file the reply. my lord.
Then where are you
I'll
wasting
file the
time?
re- No, government has not filed the affidavit, man. Let the government file the affidavit.
Government will have to file an.
Yes, then only can I.
Who is 4 and 5? Okay, okay.
This is the FCI matter.
Yes, yes. Government is to file an affidavit clearing their stand. On oath. On oath.
Oh, no.
The petitioner has projected that when land acquisition process was undertaken by the respondent number 2 in LA case number 1/2007 for for establishment of FCI godown. The grievance of the petitioner is that while acquiring land for establishment of FCI godown under LA case number 1 of 2007, an area of land measuring
1 kata 17 lakhs.
1 katha 17 lessas has been handed over to the FCI beyond the land acquired. Full stop. Accordingly, the petitioner claims that he should be given additional compensation for the aforesaid land. It is the same such contention, according to the learned counsel for the petitioner, is ascertained through.
Letter dated by the.
Where is that letter?
That is the annexure 3 mile, page 60.
Ascertained through annexure 3 communication issued by the Deputy Commissioner cum Collector Land Acquisition to address to the General Manager of FCI, whereby it was clarified that excess land are in occupation of the FCI and therefore there should be an payment of additional amount to the tune of 13 crore 3,13,810. Full stop. The FCI has filed an affidavit and has taken a specific stand that they have been handed over the land what has actually been acquired, and therefore there is no question of payment of additional compensation. In the aforesaid backdrop, the Deputy Commissioner cum Collector shall file an affidavit clarifying the aforesaid two contradictory stance of the petitioner and the respondent FCI. Full stop. Mr. Talukdar, learned senior counsel, submits that the deputy commissioner will be granted 3 weeks time to file such an affidavit. After Bihu. Prayer is allowed. Please this matter on after Bihu, last part of April. 29.
May I please?
Yes, what is this?
It pertains to expressia, my lord. Instruction is
Expressia relating to what? Accident?
Accident,
Accident,
your
my
worship.
lord.
Son and brother. That accident.
Dispose of. Who died?
Son and brother. There is two petitioners. One
Okay.
is mother, one is brother of the deceased.
Okay. Dispose of.
Lordship, I want to point out one thing. Here, Lordship, direction may be given to the district commissioner of Huzai.
Hojai.
Yes, sir.
Hojai is not a party.
Lordship, at the time of filing this petition, Huzai was working as sub-divisional officer. Right now,
District Commissioner Hojai.
Chief Justice.
Petitioner may provide petition copy along with all the necessary.
All the
documents, my
necessary
lord,
documents.
because
All the necessary
he-
documents. Petition copy along with all the necessary.
Along with the order copy.
SR signing the claim along with the order.
Chief Justice.
Lordship, may recollect on the earlier occasion, there was an order to be, two matters were to be taxed and
Where is the other method?
that matter is fixed on 4/4. That's the confusion happened.
You
let me-
told us that this matter is fixed on today.
No, it was not fixed on today. It was not fixed. That's what I think, they probably made a mention and it was not fixed on today. Let it come on 4/4.
My IA may be,
Together it,
no,
everyone.
I am withdrawing.
Withdrawing.
I,
Okay.
because your lordship, it will get delayed, your lordship, otherwise.
Mr. Bothapur Learned Council submits that he may be allowed to withdraw the present application. Prayer is allowed. Accordingly, IS is dismissed on withdrawal. And 1278, isn't that it?
Not.
Then list this matter along with WPC.
WPC,
See the date. Are you sure? On
yes,
that?
On 4.
this is the order.
Other
On
matter is
4.
on 4.
Okay.
WPC, 8462/22
On 4th of April.
on 4.
Okay.
Lordship, the IA is 3298.
No, I is 1278 interim order.
My IA is your lordship, 3298.
329.
What is I 1278?
That was for a clarification regarding the interim order person to which the main.
Okay.
Mine is 3298.
Who are you, Mr. Bothapur?
I am your lordship, all Assam tribal conference. We wanted to complete ourselves.
I am respondent number 5. And your lordship kindly pay this order.
Why you want to withdraw?
Lordship, they are not filing objection. Ultimately, on next date, your lordship, again, there will be time for objection. They will see. That's why your
You make a prayer that I may be allowed to be intervener.
lordship.
Withdraw, no?
One thing is, they all of the kindly pay the order dated 10/8/2023, passed by the honorable. Last day. Page 6, my lord. 10/8/2023. Order dated 10/8/2023.
We have seen
Yes,
that.
my lord. That respondent number initiate appropriate action, carry out a detailed survey report claim under the protection of including the Schedule A B land. In doing so, they will examine.
Yes, Bapujari.
I think. And survey.
Report is there.
4 weeks, my lord.
Let it come on 4th together. or
It is submitted by the learned counsel for the petitioner that analogous matter being WPC
8462
8462
oblique 22.
of 2022, which is fixed on 4/4/2024, also be heard along with the present.
Copy of the
Prayer is allowed. Full stop. This course under its order dated 10/8/2023 directed the respondent number 1 to 4 to initiate appropriate action to carry out a detailed survey of the land claimed to be under possession of the petitioners, including Schedule A and B land. And on completion of such a survey, a comprehensive report was directed to be placed before this court within 4 weeks. Full stop. Mr. Borpujari, learned standing counsel for Revenue and Disaster Management Department, has submitted a report in this regard. Submitted in this regard.
if I submit whether the second page, I don't. Second. That's in whether the order and has been substantially complied, but some aspects of the matter are yet to be clarified. That will cut out from the extra sentence. So when I did that, sweet, but within the private area. Now, to what extent have the authority say that purchase? That was that might have that that might not that might that might not
No, suppose, just a minute. Suppose, according to them, from whom they have purchased from Mr. Chaudhury's client? No. Okay. Okay, other person. Assuming for a moment that these are genuine, not forced. What law says?
then also might not
This is one.
Yeah.
And there are judgments, there are direction in PIL.
I think put some in my lot.
Pratyut Bora, then earlier there were judgments long back. Line of decisions. So therefore, why should Mr. Chaudhury raise a question of fraudulent? Then we'll have to send it to the civil court.
No, my I never say what I am submitting, my lord.
If you want to say, you
Yes,
can have one
I-
case
I-
that see whatsoever genuine, it is void ab initio by virtue of this. So
160.
one determination is required to be made is whether it's a tribal well
Yes, sir.
and whether if somebody genuinely sells also,
Yes, sir.
then it
Yes,
is
sir.
to be made your fate. If you say that there are some dispute that fraudulent all, then we'll relegate it to the civil court.
Not necessary, my lord.
Why not necessary if you raise this dispute?
No, I have never raised this
Do
issue,
they
my lord.
respect the
My lord, my humble submission before your
Huh?
lordship is that my line of train has not placed properly, but I am arguing. I am arguing that it is a schedule chain, my lord, in tribal belt and mend.
Let the
Non
report
tribal
is furnished to us, lordship, then we
transfer
on court.
uses possess the particular plot of land, my lord. That is my argument before your lordship. To that extent, they
Lordship.
want to protect.
Who are you?
My lord, I am the persons, my lord. Some part of our land has been, they said that they have been, my lord, encroached in our land, my lord.
Who encroached your land?
My land, my, and
They
that
have
I,
encroached land.
yes, my lord. And
That
that,
is a different cause of action.
my lord, I am coming, my lord. Only their civil code has been barred.
No,
So-
I'm not saying. There are two issues.
Yes.
One issue is whether the land purchased in a tribal well is permissible.
Yes, sir.
And if not, what the course of action to be directed.
Yes, sir.
Now, at whose behest we are taking up this writ petition? That is the another important question.
That's all.
Now, if you say that there is a case of encroachment, that is a different issue
That is
altogether.
the first case, he said, my lord. That is the first case.
That is a different course of action.
Last week, this case has been.
Is that it?
8462.
And I am the, my lord, complainant. On the basis of which complaint, this process has been initiated.
Tell there.
Yes, my lord.
Tell there.
Yes, my lord.
Where is going to the
Yes, yes, ma'am.
disputed encroachment? You say that I have lodged a complaint.
Yes, ma'am.
My complaint is not addressed. Therefore, I have come to this
Yes,
writ
ma'am.
No,
petition.
Lordship, they are-
Now the writ petition was disposed of,
Yes, sir.
directing to make an inquiry.
Yes, my lord.
After that inquiry, something was done that is challenged in one writ petition
Yes.
and they sought for some documents
Yes, sir.
that is challenged in other writ
sir.
petition. This is a short method. If you if you want to
No,
complicate.
no, I don't want to complicate it.
Lordship,
Better I keep mum. Talk senior बोलिए.
If he's a whistleblower, then we'll send it to the division bench. We cannot take whistleblower's case sitting singly until and unless he said his private right is defeated.
Yes, he's private, he's saying that it is his right.
Then we'll have to send it
No,
to
no,
the
I
whistleblower should get his own place. That is in the court number 1.
I file a complaint, my
Lordship may
on
pay.
the basis of which whole process has been initiated. I am a tribal.
No,
man.
Bharpoojar is saying you are a whistleblower.
I don't know. He said.
Okay. On 4th.
And a copy of the report we will give.
Okay. Copy of the report. No, report we are not giving at this time. Or do you propose that he should get the report?
Let us schedule for the both parties schedule then.
Yes. Okay, a copy of the report be Mr. Bharpoojar shall furnish copy of the report to all the learned councils representing the parties so that the parties can respond on the next date fix, by the next date fix.
Deeply.
Okay, a copy of the report along with the communication addressed to Mr. Bharpoojar is kept on record. Have a Xerox and give it to. Huh? Okay. Okay. WhatsApp not to all. Some person do not use all this. For all purposes.
What if the affidavit not kept the state affidavit? Lordship, I have received instruction 2 weeks time.
2 weeks time. Okay, Mr. Chaudhuri, B. Chaudhuri, Learned Council, Standing Council for Finance and Taxation Department submits that he has received instruction and will require 2 weeks time to file affidavit in opposition. Accordingly, matter stands adjourned. List after 2 weeks, last part of April. 25th of April 2024. Interim order pass earlier shall continue till the next date of this.
The matter pertains to reclassification of the traditional plot of land from agricultural to non-agricultural plot. Last petition was also.
Now your issue is that, what is the issue here? That has been converted. Not
Please
yet.
issue regarding the amount, premium
Yes.
amount.
That is what,
Yes.
that has been converted. Your case is that what should be the price
Yes, now
on the
it is
date of
higher than
application
earlier, but
or on the date of notification.
As per the DRC committee report, my amount is amounting to 3,30,000. Now, according to their impugned notification, the amount comes to 10 lakhs.
That-
There is a difference of 7 lakhs, 7,20,000. And the approval from the DLC was done way back in 01/02 2021 as well.
It needs some deliberation. You cannot straight away say that because of that principle is taken. You have a case, might be you have an arguable case, but for determination, many other aspects is to be looked into. what is the decision? Here, what is the procedure? Valuation, what is the procedure
Sir,
of
we
doing
have-
a valuation?
We have made categorically stated in our abovements in page number 11.
No, no.
Para A.
So before you were notified that land is settled and this is your premium, there may be a determination of premium.
Yes.
What is the procedure and stage of determination of the value? Stage is not at the, because it is, suppose you file an application. It is not a right that you are entitled for settlement.
At
But-
that
but
particular,
my
date.
lord,
it may be
but
later
lot
on.
No, no, just listen to us. We are not against you. These are the thoughts. So application per se will not say that you are entitled for the settlement. A procedure is prescribed. Somebody is to be satisfied, these conditions are there, so this person's name can be recommended. It is recommended to the second stage. Now, second stage, they take a decision. But it is subject to payment of revenue. Now, what is the procedure of taking that this should be the premium?
according to the existing right of the plot of the land
Where is that?
that we have categorically stated. And
No, no, we are not asking about your statement. We know your case. You say that it is 3 lakhs, so it is given. What is the procedure so that we can have a light upon that, yes, this should be the cutoff date where the price should be fixed.
That procedure probably, my lord, in 2015 act and rule itself.
So
That
let
I
us-
have to go through.
Okay.
And in
Okay.
fact,
When
response
we'll
is
get
response
this
is yet to be filed, my lord. So let me.
affidavit.
Yes, my lord.
This is a matter of 2023. Who
Yes,
you want to
madam.
file affidavit?
We have time, 2 weeks time may be granted for
Okay.
filing affidavit, my lord.
Garnet State Council prays that she may be granted 2 weeks time to file affidavit. These are the issues you'll have to address.
My lord.
Factual, there is no dispute.
But premium will be determined
What
after.
should be the premium?
Yes,
file an
after
affidavit.
recommendation of.
File an affidavit incorporating the stand of the respondent state
Right.
regarding the ways and means of determination of premium
Premium.
as well as the কি করলো? means and ways and means of determination of the premium and the basis of fixing such premium. List accordingly.
Okay.
Matter of the last petition, contact this product, produce some instruction. We want to file a reply to this.
The learned counsel for the petitioner.
My lord,
Re-
reply is not required, but we have not filed any affidavit.
Not affidavit, some
But
instruction
this is
there.
a covered matter, my lord, sir. Actually,
This is railway.
railway, arbitration, my lord. Our High Court, my lord, has held
What has held?
paragraph, my lord,
Where is the judgment?
judgment is there. In section point number 2, my lord.
Hmm.
Two and three, my lord.
Point number? Which page?
My lord, the instruction which I have, you see, my lord. There, the same amount is, my lord, more than 20% of the contract value, that is 41.03%. And on that issue, my lord, our High Court has held, but paragraph 23 is the relevant for, the operative part.
Just let him have, you want to have some time to go through your instruction.
No, that's
Okay, Mr. H. Gupta, learned counsel for the respondent railways.
No.
You are railways?
No.
Railways.
CGC,
Huh? CGSC. CGSC. Besides CGSC. Relying on a decision of this court in MSATW within bracket India Private Limited versus Union of India and others dated 20/2/2024 submits that the that admittedly the claim of the petitioner being below
more than 20% of the contract value.
being more than 20% of the contract value. Comma, the dispute is not non-arbitrable in terms of clause 10(1) of the
My lord, here it
Contract.
would be, my lord,
Clause?
clause 16.2.
16.2 of the contract agreement. Full stop. The learned counsel for the petitioner submits that he may be granted some time to go through such judgment and respond. Full stop. Prayer is allowed. Huh?
3 weeks.
List of the 3 weeks. Loss is yours. 3 weeks. Okay.
45 come to the order.
Hmm.
Actually, I was a counsel for the respondent.
Hmm.
Lordship, take up in this case, Lordship, simple, the appeal was dismissed.
Hmm.
But here, Lordship, page
Where is that?
29.
Where is the judgment is not?
Lordship, this is WPC 887 2023.
Huh.
Srimati Purnima Parma.
Now, what is here?
Look,
What is the difference?
Lordship, what happened in that the appellate court has not given the two judgment of Supreme Court where they have no power to condone that.
Hmm.
Here, Lordship, there is a specific time limit at 90 days plus at 30 days.
Hmm.
And the appellate authority has got two judgments. Page 29, Lord.
Now, here issue is whether they can be, whether cancellation of registrant can be revoked and they can be given.
Simply, it's simple that would be there would be no any quarrel there.
That is what he want, not more than that.
No, Lord, here difficulty is this.
What is it?
Here difficulty is this, the appellate authority has entertained his appeal.
Hmm.
And that was dismissed on the ground that the authority has no power to condone that.
Okay,
That is the
but what is the law in this regard?
but if they have to prefer appeal. Because
They have to prefer appeal against
the
the,
order of cancellation.
or they have preferred an
They
appeal.
preferred appeal. That was
Appeal was dismissed for being
On-
time barred.
on the ground that the authority has no power to condone that.
Now, what is the law in this regard?
Lordship, law is very strict.
Hmm.
Honorable Tribunal has mentioned page 29. Lord. And this
Page?
honorable- page 29 of the paragraph 9. Hence, the appeal cannot be taken up on merit.
Any other, this is the law.
Yes, Lordship, this is the, have take up the,
But my lord, Marble High Court and as well as yes, High Court, it could be copied, cannot be copied, but
What was the dates?
Lordship, here there is a delay of 4.
The situation is this, if you want to have a registration and continue with the registration, if he abandons the appeal,
that is
okay, you want to abandon the appeal. Now the question is, moment which it is appeal is abandoned, appeal is dismissed on the ground of delay.
Authority
And direction was against the cancellation.
cancel.
Now he said that give me a phrase.
He can apply for phrase. There is no bar. That can be.
That is different.
That can be.
Even I may apply, but I have already, whatever may be due, whatever I have not been, I have already in this, I would want it, I could just clearly stated that the petitioner has not been paid, the dues also. Even the.
No, therefore, whether a writ court in such a situation will have the power to ask you to have a
Phrase registration, there is no bar. Till I talk to the commissioner also.
can direct the cancellation of the.
But if,
Now, what is the remedy against the appellate order?
a case lordship, because there is no appellate tribunal, so we have to approach this honorable court.
Okay,
That-
we cannot, because in virtue of the apex court judgment, we cannot, according to you, say that, okay, delay was wrongly not condoned, you hear the appeal.
Yes. That-
That is your case. But what remedy can be done?
He can have a phrase registration.
Let us think over this.
But the paragraph 10,
Only my, for your lordship.
Oh, Mr. Your only request, only prayer will not do.
Yeah. my lord, yes.
You will have to see the what is the law and where is our power. We cannot pass because
Yeah.
this is a case, give it. I will have to give reason.
Yeah.
The appellate authority relied on certain judgments of the apex court.
Yeah.
We'll have to say this is not made applicable in this context. What is that context? Only for the prayer that High Court has decided.
lordship,
I would may say High Court judgment is not correct because that was not brought on record on at that point of time.
that is the difficulty with the department lordship. I thought, and had the, if you would not have preferred appeal, we are considering in many cases lordship has given direction to for restore their rights after paying, because the section says.
Okay, we'll handle this in a different way.
No.
Where your authority is also not disturbed
Yes, Lord.
in a different manner.
Yes,
Let us-
Lord, that can-
That we'll have to argue. My lord, give me is not a
Yeah.
argument. Okay,
Yes, ma'am.
you will have to enlighten that this is your right. This is a power of a judicial review. Without interfering that you can do it. You will have to argue. On the prayer of the learned counsel for the petitioner, matters then adjourn and be listed after view. Let us think over it. We understand because the appellate order clearly says this is the
This is-
judgment. They are bound.
And we have to
We-
overcome.
in fact, we are also bound by the judgment. So whether we cannot say that appellate order is bad.
Yes.
Moment appellate order is bad, the cancellation is upheld.
Yes.
If cancellation is upheld, how can we bypass all these things? That will have to enlighten us.
My, your lordship,
Yes.
that the matter may be referred to the authority, they may be. But
How can they decide? They have taken a decision. Appellate authority said your decision is correct. Can they review their decision? Is it permissible? If not, then there will be difficulty. Then we will give a permission. They will take the advantage of that, and every now and then they will do it for their whims. So give us some solution. We are here to pass order, not to argue on your behalf. You have your way. You will have to show us that road.
Different High Court passed order restoring the registration, but the situation is different.
So situation is different because nobody has went to appeal and comes and says, just give me, these are my undertaking, will this, I'll pay this and this. Okay, restore.
This the honorable court also in many cases, even such type of direction. We have also considered.
Now here is a case is you have preferred an appeal and appellate authority relying on a decision of the Supreme Court says we cannot.
that is the,
That we'll see. Last part,
definitely apply.
last part. বহুত disadvantage actually. Note down কৰিছে নে নাই? কোন না কিমান দি আছে? Yes, yes, next case. 24. Next case.
Item 40.
On the last occasion.
Yes, Gogoi. He is a social worker. He helped drugs and all.
My lord, may kindly press paragraph 8 and reflect lordship
how is
You want to say he's also part?
paragraph 8 lordship? We'll place it by way of affidavit lordship. Then my brother will
So
also
for the
lordship.
criminal case, that have any documents also. You was the petition.
But there are indirect apprehension that you already killed
No, my
people.
lord. This person was sliced like anything. I have even photographs also.
But see, Mr. Das, problem is this. If they say no threat perception, how will you
That's
assess?
fine, my lord, because there is a committee place, let them bring
Committee also
that
opined that
rejection,
paragraph, subsequent paragraph lordship.
that rejection decision cannot be arbitrary. If in a given case, a person is really facing threat, if the papers will not see, at that incident not have happened, then there is no threat person.
When lordship started also, his name was reflected in serial
This
number
was
1.
cross case, my lord. This was a cross case. So far as
That
I
time
remember,
indicated lordship.
because he was
Okay, you
attacked.
file an
There was-
affidavit if necessary, keep the committee's
Lordship, lordship,
discussion.
lordship.
Yes,
Mr.
but delivery-
Gogoi, learned counsel for the respondent submits that he has received an instruction and parawise comment,
Lordship.
and accordingly placed for 2 weeks time to file affidavit of opposition. Prayer is
The
a
assessment of the committee can be incorporated in the
It's-
affidavit. That would be, otherwise there is nothing in the
Lordship,
instruction.
no need to indicate will lordship.
no will not indicate.
Lordship.
Yes, no, my friend will do it. That's the-
Accordingly, methods necessary.
Lordship, lordship.
If necessary, we'll see
Lordship.
the record.
Lordship, lordship, lordship.
Give it
Lordship.
after 2 weeks.
DPO.
Yes.
It is my lord.
Hmm.
My lord, here we are serving as the chairman of a regulated market committee,
Hmm.
and the tenure of the market committee is for 3 years. And the Act, Assam Agricultural Market Produce Act.
Now tell us, what is the procedure and what is the procedure for election and what is the mandate to have an election?
My lord, if my lord looks at section 9, it clearly says, clause 1, that the market committee shall thereafter be reconstituted every 3 years before the expiry of the 3rd year and not earlier than 3 months prior to the expiry.
Okay, suppose this is not done.
Yes.
Fact is that within 3 years it was not done.
Yes.
Extension was granted twice.
By order of the court. We don't know whether they have passed a speaking order. for
Anyway,
everything.
there were extension twice.
Yes.
Now, what
Once,
is the
once.
once? What is the power to give extension?
My lord would have it at section 9, clause 3,
What it
which
says?
says the state government may, by notification, for sufficient cause to be stated therein, direct from time to time that the term of the office of the members of the market committee can be extended by such period not exceeding 1 year as may be specified in the notification.
And what is the 1 year in one time and what is the maximum period?
Well, that is not prescribed. But the mandate is that the committee
Okay,
should
that
always
is not
function.
that is not prescribed. According to you, that can go on as per the wish of the state with a reason notification.
Yes.
So no, so in generally in certain acts, it is that 1 year at one go, maximum 3. There is nothing in this act.
Nothing like that, man.
Huh?
No. 1 year at one time.
1 year, one
Yes.
time or many times. Maximum 1 year. No, there are two aspects. Maximum 1 year for a period or 1 year, maximum 1 year at one go, but it can go for second term, third term. also.
But the language is there, the state government
Subject to provision of section 3 of the market shall effect in the manner way. For which provision?
Section 9, clause 3, my lord.
9C.
9(3).
The state government may by notification for sufficient work to be stated herein direct from time to time that the term of office of the members of a market committee be extended by such period not exceeding 1 year as may be specified in the notification.
Okay. Okay. Okay, now that 1 year is gone.
Yes, sir.
Then what is the prescription of the act?
But after that, what happened was the,
No, we are not interested for the time being in what happened. We are interested in what should happen in terms of an statute.
Lordship, for a moment, can you take the rule, Lordship? Wherein
No, tell us, suppose there may be many situations, marketing committees elected 3 years tenure is over.
Okay.
Before the 3 years tenure is over, like that we are having an election. 5 years term will be over in the month of May. So the election commission has already notified. There cannot be any extension that we have not notified. Suppose you have not notified.
we only notify Lordship.
Hmm.
In the year 2020, and prior to expire of that 3 years.
Okay, then what happened?
After that, election was not held.
Why?
Because the government will held the election.
Okay, election has not held. Then
After that, the extension was done. Lord.
Hmm.
They-
Then
they-
thereafter,
Thereafter,
when extension is over, you have appointed an executive, chief executive.
Lordship,
Where is that power?
that is section 48.
Section 48.
Power of state government to delegate its power. Lordship.
No, that is your power, but under what circumstances and that can be
That is not. That
now. So therefore, suppose no election in held, what is the what should be done? Who is representing the government?
I can-
Yet what do you
Now
say?
the district officer is taking the charge and his term was over, Lordship, on 39/2022.
No, that we understand. We are not on him. We are on what
The
are you
election
doing?
elect.
What are you doing?
Now at present, Lordship, the district agricultural officer is holding.
For
the
how
office, but I
many?
need to
Because
take
the
my-
object of the act is something different.
Yes, Lordship,
Not
because
to run a marketing board by through an executive officer.
their instruction, Lordship, I need to take. So I pray for 1 week.
My lord, till then status quo be maintained, my lord. But till date, I'm
That
running
is
the
impossible
committee.
because, Lordship,
I'm
his
still
term
running
is
the
already
school.
over.
My lord, because if I may draw my lord's attention to section, just one moment, my lord, section 37. If my lord peruses the language of section 37,
Hmm.
it talks about supersession of a market committee.
Hmm.
I read, my lord.
Just
If-
a minute.
Yes.
Section
37.
37.
If in the opinion of the state government, a market committee is not competent to perform or persistently makes default in the performance of the duties imposed on it by or under this act or otherwise by law, or exceeds or abuses its powers, the state government may, after giving the market committee an opportunity for submitting an explanation in regard to the matter by notification, stating the reasons for doing so, declare such market to be incompetent or in default or to have exceeded or abused its powers as the case may be, and supersede the committee for a period not exceeding 1 year at a time, or dissolve the committee and reconstitute as soon as possible.
Hmm.
Provided, when the committee is superseded or dissolved, the state government may appoint any person as chairman to carry on day-to-day routine matters on behalf of the committee until the same is reconstituted and a new chairman is elected.
Hmm.
Now, my lord, may kindly go to the impugned order,
Hmm.
which the notification that I have impugned. My lord will look at the language of the notification.
Yes.
Page 53, the
53,
district
my lord.
agricultural officer is given the task.
My lord, in my humble submission, this amounts to supersession in terms of section 37.
Supersession will be during the tenure.
My lord,
Where
the
is your
scope-
tenure? When it was done?
my lord, I was continuing by virtue of the honorable court's order.
No, we understand.
Yes.
Page 49.
Session means a period means 3 years.
Yes.
You were on a extended period by virtue of an order of this court.
Yes, ma'am.
Okay,
Yes.
fine.
Yes.
Now, that provision, section 37, envisages a situation where a marketing committee is found to be committing some illegal acts, etc.
Yes.
Then government is not powerless.
Yes.
Then government has been empowered to remove
proceed.
you and do something different.
Yes,
That is a totally different
My-
situation.
my lord will only look at the proviso. My submission, my lord, is that under the act, this is the only section under which the government
Understand,
can
this is
appoint
the
its
on, this
executive.
is the only section under which an executive can be
Appointed as chairman.
appointed.
Yes, this is what has been done in this notification, my lord. There's no other way that they can appoint an executive.
No, no,
to run a committee.
understand. That is
My
can be
lord-
done.
Yes.
Now, that is why my first question was, under what circumstances executive officer can be appointed?
Yes, that is
When
under
this
37.
is one, only according to you, only
Yes,
37.
yes.
But my second question was, when a period is over, election is not held, how marketing committee will be run?
That is the reason, my lord, the word shall is used. No committee shall be without election. Always an elected
So
committee
there-
has to be there.
Therefore,
Yes.
now they will have to obtain instruction when they are going to hold the election.
Yes.
Till then, we are not interfering with, because you are not having a right to continue beyond the period of election.
My lord, in the earlier round of litigation, the honorable court allowed us to continue because we were able to satisfy that they have failed in their duty to hold the elections, notify the election committee, etc. So for
We'll
their
examine
default,
that,
whether it
that
is-
will amount to whole determining the whole case.
my lord, my only request is that because we're currently holding the committee, let it not be broken up. We may be allowed to continue. Let them obtain the instructions on the next date.
No.
Till the next date, I may be allowed to continue, my lord.
No.
Because so far, I have been enjoying the protection of the court.
You want a rejection of your interim prayer, or will await for instruction?
If my lord considers it on the next date, then
We'll see, we'll see.
my lord may indicate that the interim order will be considered on the next date.
MS R. Bora, Learned Standing Council for Agricultural Department, prays that she may be granted a week's time to file affidavit in opposition, clarifying the stand of the Agriculture Department, more particularly the question raised by the petitioner that the state government is having, state government in agricultural department is having no jurisdiction to run the marketing board, replacing an elected body by an executive officer, except in the contingencies as advises under section 37 of the act. In act, it is the case of the petitioner that the impugn order of appointing executive officer to run the marketing board while an elected body was functioning, may be beyond your tenure, is not permissible under law. And in the scheme of the act, when election is not held by the government, the earlier elected committee should be allowed to continue. Mr. MS Bora, MS Bora is granted 10 days time to file affidavit in opposition. Place this matter on after 10 days. Too many matters you can again. 25th pare. 24th. Today is
The 18th, madam.
Huh?
18th.
18th. Can you file by 25th? Or you have the instruction? In what instruction? This is a question of law. We can argue that. That's all. Where is your power? You'll have to show that only. According to them, except 37, you cannot appoint executive. If you can satisfy, no, dear, these are the contingencies where in the under the scheme, though there is no specific provision, court is that state is empowered. Another question will be, it is your fault to hold the election prior to expiry of the marketing committee. If you are not holding, instead of giving an executive officer, why should not the already elected body be allowed? Devil and the deep sea. Isn't it?
Also, interim order may be considered.
Huh?
May be considered under next thing.
Okay. If no such affidavit is filed, interim order as paid for shall be considered on the next day.
Are fixing on 25th?
25th is too early.
Too early. Second,
Third, fourth,
Would be on 29th, my lord.
fourth,
29th is already.
fourth, April.
First.
No, first of April.
I think.
Order.
I'm
Yeah,
sorry.
I'm for F1 of 4 and
Sorry, my lord, hearing
Anything survives?
not surviving, not surviving.
Anything survives?
Surviving.
According to things happen. They have failed in the for the people, for the assembly. How they are trying to the
I don't hear it. For the top of.
No, we'll hear it, no problem on it. We will not like to hear infectious matters.
My lord, to be submit fairly, not infrastructure.
Okay.
I will
Mr. But it is a by order method.
My lord, this made long back, but it. My help is not.
The learned counsel for the petitioner seeks for an adjournment. Prayer is allowed least after 4 weeks.
open.
What you want to say? Where is the hearing people? We cannot blame them. 1-5.
গুৱাহাটী মৌজা চহৰ গুৱাহাটী দ্বিতীয় খণ্ডৰ 795/771 দাগৰ জমিত অবৈধভাৱে সুৰ চলা বিলত দখল কৰি থকা দেখা যায়। এই জাননী পোৱাৰ 3 দিনৰ ভিতৰত বেদখল মুক্ত কৰিবলৈ আহ্বান জনোৱা হৈছে। অন্যথা ভূমি ৰাজহ আইন 18(2) ধাৰা মতে আইনগত ব্যৱস্থা লোৱা হ'ব। Now, my lord, so for first thing, my lord, 18(2), my lord, is states that some reason why the land is required. That is to be there in the notice.
Where there is a series of judgment where says under 18 no notice is required.
My lord,
Some judgment says some notice is required.
yes,
Now that matter is referred to a larger bench which is being taken up tomorrow.
correct. My lord, 18,
But most of the judgments are no notice. So let me not comment at this stage. I am part of the division.
my lord, in that case, my lord, previously also, my lord, in page 25, this is a judgment order in earlier round of litigation. Sir. And here, my lord, notice was given in 29/11/2012 and was served on, my lord, 16/1/2014. Page 26, my lord, last paragraph, the second last paragraph. Since it is the specific allegation of the petitioner that they have been served with notice dated 29/11/2012 only on 16/1/2004, it will be appropriate for the petitioner to show response to the state notice by filing
What
representation.
happened, Director?
I have filed a representation and till then that the status was granted. Hello, representation is page 28, original is, my lord, is at page 31.
Now what happened, Director?
Well, they have not considered this representation. And after this notice, my lord,
impugn notice, I have again represented them in test 37, my lord.
This is the difficulty, Mr. Sharma. You obtained the instruction only on this ground
What happened to the earlier report?
earlier. Because see, there is a specific order.
Lordship, I have seen.
That status quo till decision.
Till then.
If you have decided, then matter will be different. If you have not decided, that will be different. Heard Mr. B.K. Das, learned counsel for the petitioner. The petitioner is aggrieved by and proposed eviction. Aggrieved by notice dated 13/3 proposed eviction. A notice dated proposed eviction is aggrieved by a notice dated 13/3/2024 issued under section. It is not it. Okay.
No, Rule 18(2).
Rule 18(2)
Yes.
of the Assam
Land and Revenue Regulation.
no
It is-
settlement rules, not under regulation.
Yes, sorry.
18(2) under
Razo Ainur.
no, it's
No,
not
it
I.
is stated Bhumi Razo Ainur.
No, that is their mistake. Settlement rules. Under comma 18(2) of the settlement rules.
Right.
18(2) of the settlement rules. No, I'll give the details. Settlement rules. Settlement. The basic grievance of the petitioner is that earlier notices were issued for eviction. However, this petition notice for a similar notice of eviction was issued to the petitioner. And being aggrieved, the petitioner approached this court by filing WPC 1489/2014. This court, under its order dated 13/3/2024, directed the respondents to 13/3/2014. 2014. 2014. And this directed the respondents to consider the representation, to file representation within 31/3/2014, and the event such representation is filed, the authority shall dispose of the claim of the petitioner by passing a speaking order as expeditiously as possible, preferably within 15 days thereafter. And till then, status quo as on the date of the passing of the order dated 19/3/2004 in respect of the 14 was in respect of the land was directed to be maintained. So the case of the petitioner is that the petitioner preferred representation immediately
29/3.
on 29/3/2014 before the additional deputy commissioner Kamrup Metro Guwahati 1. However, till date, such representation has not been disposed of, and instead a fresh notice has been issued. Full stop. What to do? Issue a notice?
Not
Or-
necessarily. Let it
Okay.
come in the motions.
Motions.
In the meantime, we will get the
Motions.
instruction.
Okay. In the aforesaid backdrop, Mr. Sharma, A. Sharma, learned counsel representing the deputy commissioner submits that he will obtain instruction as to whether any speaking order has been passed in terms of this court's order dated 19/3/2014. 19/3/2014. Full stop. Accordingly, matters stands adjourned and same be listed on
First week of April.
give a date.
Let it be on 10th of April.
10th of April.
Lord.
10th of April 2024. Till then, considering the method that there was already an order of maintenance of status quo till passing of a speaking order, and in view of the specific stand that such speaking order has not yet been bastilled, comma, it is provided that the respondent shall not give effect to the impugned notice dated 13/3/2024, 13/3/2024 till the next date of listing. Inform it, Mr.
Lordship, I had a talk with, actually, I have a talk with the circle officer today itself. He told me that because of this election, they are not going to act upon the notice. So that is why I am taking it up to 10th, Lordship.
Just have informed them
Lordship.
that.
Obliged. My lord, here, my lord, we have filed our
Everybody has
written approval.
submitted everything, only my job is left.
My lord, lordship may take, my lord, time, my lord, because during vacation, lordship might have time, my lord.
List, hearing concluded, judgment reserved.
Obliged. Deeply.